Hello.
Yes, I can hear you now. You have muted yourself now.
Sorry, sir, I got a call. I'm really sorry for this distance.
Don't worry. All these things do happen. All
Thank
things
you.
will continue.
Right.
Feel
So,
absolutely free and at ease.
yes, sir. Thank you. You're very
Yeah.
understanding, sir.
No. It's required because that learning can only be done in an informal manner, and also when you are free from all those discipline rules and regulations.
Right, sir.
Yes.
So, first of all, we are very thankful that you took some time out and you are here to join us in this meeting to give your professional advice to all those who are into arbitration or are going to choose arbitration for their future prospect. So, thank you so much, sir.
Thank you so much. And I thank you, Nandini, a lot for getting me here on this platform today. And also Mrs. Shivangi Sinha, the head of the cell and team of Madhyastha ADR cell, Bharati Vidyapeeth, deemed to be university, new law campus, RN1A campus in Pune. And also all your professors and honorable vice chancellor and all the esteemed faculties who have enabled this wonderful platform for the benefit of students.
Thank you so much, sir.
Yes, please.
So, without taking much of your time, shall we proceed to the question and answer session?
Yes, please.
Sir, I would first like to request if you would please like to introduce yourself to our guests, to our viewers, sorry.
Okay, my name is Colonel Dinesh Kumar Bishnoi, and I'm a retired colonel of Indian Army. And I'm now a practicing advocate in Bombay High Court.
Okay, sir.
And I am a fellow of Chartered Institute of Arbitration, London, fellow of Australian Institute of Arbitration, New Zealand, and host of other jurisdictions. And my expertise is primarily in commercial, contractual, construction, and also maritime.
Okay, sir. Thank you so much, sir.
Yes, please.
So first question I would like to ask you, if you can please briefly define arbitration to those who are not familiar with it.
Okay. I take it that students who are attending to this are familiar to this question. However, I'll briefly touch upon these salient features. The dictionary meaning of arbitration is hearing and determining a dispute between the parties by a person or persons chosen by the parties. Now, this process of arbitration involves lawyers for each party, an exchange of information about the situation, a hearing of sorts that includes bringing in any witness, and opportunity for each side to present their case for the situation. And an arbitral proceeding can only take place if both the parties to the disputes have agreed to it. Generally, parties insert an arbitration clause in the contract for future disputes arising from non-performance of contractual obligations. An already existing dispute can also be referred to arbitration if both the parties to dispute agree to it. That is called submission agreement. Now, this is primarily in a nutshell, this is an alternative dispute resolution method. People prefer to come outside of the court litigation, lengthy processes, and also various other features, which I will cover in subsequent questions and answers. I'll try and see where I can fit in. Yes,
Sure,
please.
sir. So the next question I would like to ask is, if you can dispel one common myth about arbitration.
Okay, that's a very good question. And I compliment you for asking that. A common myth about arbitration is that it lacks transparency and allows for arbitrary decisions. Now, with this, I would cover that generally it is taken that because it is confidential in nature, so this lacks transparency. And because any decision could be passed within that framework of the contract and the law and the rules which have been chosen by the parties. So it is called, sometimes it is referred and understood mistakenly as arbitrary decision, but it is not. The lot has been said on this, and it's a very wide topic. And I can only say that whatever parties have chosen for themselves, whether it is confidentiality, and to whatever degree confidentiality can be enforced or compromised, it's all with the parties in their hands. And once the parties decide, and then they can proceed ahead. So there is nothing to worry about this, and there's nothing like this. It's all as per the parties' contracts, the rules chosen by them, the law opted by them, and also the arbitrators chosen by them. So all these are with the parties, and it's all in the framework and law of the land, of course. No arbitral tribunal can afford to ignore the rule of law or the basic and fundamental principles like natural justice or the due process. All these are there as a essential and fundamental part of any arbitral process. Thank you.
Sir, excuse me for a minute, please. There's something making noise in the background. I'll just turn it off.
Yes, please. Yes.
Thank you, sir. Yes, sir. Sir,
Yes.
next question I would like to ask that from an employer standpoint, what are the primary reasons for choosing arbitration?
Okay. Nowadays, what happens that since the benefits of arbitral process or the alternative dispute resolution systems, it has become a hit now. It's a great success. It's a grand success story. Because of that, lot many places and lot many fields are coming into the ambit of arbitration day by day. And it's the field of the arbitration which was conventionally confined to contractual. Now it is expanding into the tenancy, into the also the other fields. And one of the field which has not been a great success, or it is not on that scale, which is there in the Western countries, is the arbitration in the employer-employee disputes. So this is basically now in the Western countries, they have this by means of an arbitration clause in the contract. When the employee is appointed, in the appointment letter itself, the employer mentions an arbitration clause, and this clause regulates all disputes like in any other arbitration, past, present, future, whatever in that nature. So this controls all the disputes between the employee and the employer. It is yet to take a shape in our country, but the primary reasons are that the employer often choose arbitration. The first point is that because of its efficiency and speed, because arbitration, when it takes off, there is no looking back. And if parties are cooperating with the arbitral tribunal, it takes least time. Then the other point is cost saving. It saves a lot of costs. And then it's a choice of arbitrators. And then the parties can choose the arbitrators. What a flexibility. You can choose your own judge who's going to decide your case, in whom you have the confidence. Then we have confidentiality. You can define confidentiality, or to what extent you want it to be confidential, or you want it to be open, or you want to be a partially confidential, or what part can be disclosed, or what part can be public, and what could be in camera, or what could not be disclosed. All that. Then it's got a other point is a flexibility in process. It's such a flexible process that strictly speaking, the civil procedure courts and the strictly speaking, the provisions of evidence acts, they don't apply. But you can't completely ignore, you can't have a situation where you don't follow any rules. So the basic principles are, of course, absorbed and implemented, but then strict implementation is not required. Then a reduced risk of appeals. Because of its fundamental and in a very shining example is that if you do not have any ground, then it cannot be challenged. It can only be challenged when there is a violation of a process of natural justice or a breach of due process of law. It takes finality, and finality is something which gives a great shape to arbitration. And this is a characteristic of arbitration wherein the tiers of litigation in future are taken care of. And the other point is the less adversarial atmosphere. It's an informal nature of arbitration. It can foster less adversarial environment. So basically, because of these points, the employers are now increasingly opting for adopting the process of arbitration in their disputes. And there are other factors, commercial factors. Now, what I have covered are the legal points. Now, there are societal, there are commercial, and there are other factors. I'll just briefly touch upon commercial factors. No industrial management would like its reputation to take a hit. They would not like it to get into social media or print media or in any other form. They would like to resolve it within their four walls and amicably resolve it so that both the parties are satisfied and both the parties settle. And that's the reason that lot depends, because once you take the recourse to litigation, you go to the court, nothing is confidential. So everything is in public domain. And then they have their stakes, lot of stakes in the market. They have their equity shares, they have their on the stock exchange, they have their creditors, they have their debtors, there's the public faith, confidence is involved. So moment something goes out against the company management, the reputation of company takes a hit. So that is another big reason that this mode of dispute resolution is becoming popular day by day. I think balance I'll cover sometime later. It's a vast field, so we can switch to next question, please.
Sure, sir. So next question is, are there any common misconceptions that employees have about the arbitration process?
Yes, the employees have basically they feel because they have not been through to this, and it has not become popular in our country or in this part of the world. So they feel as if there is a lack of fairness. But it's nothing like that. People have gone through this. They would understand there is no lack of fairness. It's absolutely in absolute fairness. And they would be there. Their counsels would be there in case they need. Their advocates would be there. And they will ensure that the 100%, 100% fairness is there. It's such a process that it's an informal process. So it is not that whatever you want, you can do it and get away. So it looks as if it's informal, but it's very, very fair and just. Then the other point is that the employees have limited legal recourse. So they believe that choosing arbitration limits their legal rights or access to the court system. That is another myth, but it is not that. So if you have chosen while being appointed or later, so then you are bound by this. So it's a contract. It's a contractual obligation. So it's all when you agree, so you have to be part of it. Then you have to perform your part of the obligation. Then there is another point is lack of transparency. They feel there is also that there is no transparency, but it's not that, because both the parties are there, the advocates are there, their counsels are there, they have the opportunity. The process itself is so transparent when you are there inside. So that is also not correct. And there is a word which needs to go around, and what I can say that an environment has to be created in which all these myths are dispelled. Then they feel that there's an inability to appeal in this system. There's nothing like that. If there's a breach of natural justice or due process, or if you have not been given opportunity to properly present your case, you have a system wherein you can approach the court in section 34 after the award is passed. You can approach the court challenging the award and whatever you feel that you are aggrieved. And then there is another appeal in section 37 of the Arbitration Act. So it's not that. First of all, we have to see that whether it is a litigation or it is arbitration or any other method, finality is what we are looking forward for. Unless and until you have a ground, very compelling ground that forces you to continue with your process of further appeals. Then there is a point of unequal bargaining power, which they feel that management will have an upper hand. This is the apprehension of the employees. But it's not that, because there is no bargaining power. The arbitral tribunal is absolutely fair, impartial, and they look after the interest of both the parties within the contractual obligations, whatever you have agreed and whatever you have consented to, and the law of the land and the rules of the procedure permitting you to do that, and your substantive law of the land of the country, a public policy, all these factors are there which ensure that nobody has got an upper hand. The management or the company, they don't have the bargaining power. Then there is another point which I would like to just touch upon, that exclusion of class action suits. This is a separate topic in itself. Generally, what happens that employees are concerned that arbitration clauses prohibit them from participating in class action lawsuits. But this is more so in the Western countries. Here, it has not taken that popular form, and probably in the times to come, it will be more prevalent in our country also. I think that takes care of your question.
Yes, sir, sure it did. Next question I would like to ask is, are there any emerging trends in the use of arbitration for employment disputes?
Yes, the method which has evolved, what happens that I'll just give you an example. The economic disputes. Now, if you see, the Economic Policy Institute reported nearly 54% of private sector non-union employers and 65% of the companies with more than 1,000 employees have mandatory arbitration procedures. The emerging trends in the use of arbitration for employment disputes, generally, they are now on the front, like let's cover increased scrutiny on arbitration clauses. Because once you frame and you draft and you incorporate in your contract, the importance of the arbitration clauses cannot be undermined. Because the courts and the legislature have been scrutinizing arbitration clauses in employment contracts, some jurisdictions have considered or enacted laws that restrict or regulate the use of mandatory arbitration in certain employment agreements. So this is one. Second is that emphasis on fairness and transparency. Now, this is what is taking shape, is growing emphasis on making arbitration processes more transparent and fair. It includes addressing concerns about the perceived bias in favor of employers and ensuring that employees have a clear understanding of their rights in the arbitration process. Now, the other point is that remote arbitration practices. The COVID-19 pandemic has accelerated the adoption of remote work practices, and this has influenced arbitration as well. But the remote arbitration processes, including the virtual hearings, have become more prevalent to accommodate the changing work environment. Now, there are SOPs, standing operating procedures, and whatever shortcomings were noticed earlier with the passage of time, particularly after COVID-19, all these processes have been put into force, and they take good care of all those apprehensions. And second, the opt-out provisions. If you see, problem is that some employers are incorporating opt-out provisions into arbitration agreements, allowing employees the choice to opt out of arbitration and pursue traditional litigation if they prefer. This trend aims to provide employees with more autonomy in selecting their preferred dispute resolution method. Now, point here is that you have to draft your arbitration clause in such a manner. Generally speaking, whatever you have agreed, that will stay. So you can opt in generally, but you cannot opt out if you have decided that way. But if you have drafted your arbitration clause in such a manner that you've given the autonomy to the parties, that if any point of time they can opt out, then it's too flexible a method. Then it depends. If you want that way, it can also happen. It gives great flexibility to both the parties. But then you have to decide and weigh the pros and cons, and you have to take advice of your legal department or your legal advisor whether to go for such a arbitration clause. Then class action waivers and collective actions. Then enforceability of class action waivers in arbitration agreement continues to be a significant legal issue. Courts have been addressing the challenges to inclusion of clauses that prohibit class or collective actions in arbitration agreement. So this is a vast field, and in our country and in the countries of this area, demographically or geographically, it is not that prevalent, but it is very prevalent in the Western countries. So we can have a different lecture for this. Then industry-specific practices. I mean, certain industries, the employers are exploring and implementing the industry-specific arbitration practices tailored to the nature of their disputes. This trend recognizes that different sectors may have unique considerations in the resolution of employment-related conflicts. Now, different industries have got different requirements. So you can modulate your arbitration clause in such a manner or contract in such a manner that addresses the concerns of that industry or that sector, and you can incorporate some special provisions if you feel that way. For example, some industry is related to healthcare. Some industry is manufacturing batteries. Some industries are into the manufacturing of gases or chemicals or fertilizers or say iron ore or say, so all these are industry and sector specific. So they have their different requirements. Now more into this, like hazardous jobs. Somebody is working into atomic plant. He will be now introduced to a different level of radiation. Or somebody is into the transportation, or like somebody is driving a tanker, which is highly inflammable. Or all are sector specific, industry specific, job specific. So there's sector different requirements of this. So it depends if you have a higher degree of risk. So you can modulate your arbitration clause or contract in such a manner that takes care of those apprehensions. Then the point is legislation impacting arbitration. The legislative changes at the state and federal levels can impact the use of arbitration in the employment disputes. Some jurisdictions are considering or enacting laws that regulate various aspects of arbitration agreements, including their enforceability and scope. Now, like consumer disputes, or like your other, if you want to enlarge and enhance your scope of arbitration, then sky is the limit. And the state and the legislature has a great role to play. Like we have the law commission appointed, they submit their reports, which is put into public domain, and various stakeholders are invited to give their presentation, their suggestions, their modifications, and then again it is thrown open to the public, and then the various stages are gone through before it takes a shape. So whatever we feel, it's not that at the end of a story, it's a very evolving and dynamic field. It takes care of growing concerns, and wherever the pitfalls are observed, so these are taken care of by the legislative changes. And also the courts are also aware, and daily you see the judgments coming, and the courts are very alive to this. And the court's judgments and the citations and then the decisions which are being given, they interpret in such a manner, and that it's a treat to see, to read, to go through, and to discuss amongst the colleges and the universities, campuses. It's a wonderful evolving field. Now, focus on employee consent. Now, the last point I would like to cover that on this question, that you have to take the employee consent. Now, without that consent, it will not materialize. Now, there is a growing concern of the importance of obtaining clear and informed consent from employees before including the arbitration clauses in the employment contracts. Now, courts have emphasized that agreements to arbitrate should be entered into willingly by both the parties. But this is applicable for all. Now, somebody can challenge later that I was coerced into this because I was looking for my appointment, so I had to accept it. But then you are a legal entity.
Right.
So you bear the consequences if you did not want it that way and you accepted that. So all that has to be gone into, and the employees have to be told, and they have to be explained, and then the question comes that how do you educate people? And then how do you create the environment? How you sensitize their minds? And then how do you create awareness? So all these are the times. I hope you can.
Sir, I apologize. I had an event, so I had to go and I had to manage that. But I'm really thankful to you for accepting our invitation and joining for this particular session. And Nandini is the one who is going to take this over, and she'll be finishing with all the question answer. And I'm really grateful to you, and I thank you on behalf of our university and our college. Thank you so much, sir.
Thank you so much, and please convey my regards to Vice Chancellor and all the faculties, and then also my best wishes to all the students. You're doing a great
Sure,
job,
sure, sir. Sure, sir. Definitely.
and
Thank you so much, sir.
my compliments and congratulations to all of you.
Thank you. Thank you so much, sir. Really means a lot.
Yeah, thank you so much.
Thank you, sir. Please continue.
Yes, ma'am. So,
Yes, yes, please.
yes, sir. So sorry for the interruption, sir. Actually, Zoom has some
Don't worry, don't worry.
policies.
Don't worry, don't worry.
Okay, sir. So, sir, proceeding with the questions. My next question is, can you share any real-world examples or case studies where arbitration successfully resolved in disputes?
Okay, so first thing which I would like to mention here is that because of the confidential nature of the arbitration, once a dispute is successfully resolved, the arbitration award doesn't see the door of the court.
Okay.
If both the parties are satisfied and the dispute has been satisfactorily resolved to the satisfaction of both the parties, in that case, no party will challenge. If neither of the parties are challenging, then it will not go to the court. And if it doesn't go to the court, then it is not in public domain.
Right.
So the matter resolved, the arbitrator award is kept inside the box or the almirah or the drawer, and then it comes out only in public domain once it has to be executed or it has not been executed. It has to be filed for execution. Otherwise, both the parties will try and resolve the execution part of also, so that the factors which were there, which we have already gone through, keeping those factors in mind, the employer and the employee both will discharge their obligations and implement and execute that award. And there will be no requirement of any court process or execution. So this is one part. That is why the litigation is not there, and the employer would like to discharge its obligations for whatever award has been passed by the arbitral tribunal. And they would like that, since they have gone for it, so they will execute and they will perform its obligations and the matter will be over. It will only go to the court if the party is not satisfied, one of the party, and it goes to the court on the grounds which are available in section 34 or thereafter section 37. Because of the breach of due process or natural justice factors, whatever you have. So therefore, for academic purposes, you will not see much of the litigation because of the reasons which we have discussed in the court. However, we must now see the concept behind it. Now, if you see, the many employers, since the United States Supreme Court's decision in Gilmer versus Interstate and Johnson Lane Corporation 500 US 20 in 1991, are implementing employment arbitration agreements deal with employment disputes proactively. Now, these agreements are not foolproof. The enforceability of arbitration agreements between the employers and employees under the Federal Arbitration Act 9 USC 1214 Act, or we say FAA, Federal Arbitration Act of the United States, is an unresolved and hotly contested issue due to a provision in the Act that renders at least some agreements relating to employment not subject to the Act. Let us have a look on Section 1 of that Act, which excludes from coverage the employment contracts of workers engaged in movement of goods in interstate commerce. Now, historically, courts have held that the FAA, that is the Federal Arbitration Act of United States, excluded almost all employment contracts as essentially every worker engaged in the movement in interstate commerce. Now, since this judgment of Gilmer, every circuit court there to squarely address the issue has interpreted the employment exception narrowly, applying it only to workers actually physically engaged in the movement of goods in interstate commerce. Now, post this judgment, post Gilmer, after Gilmer have been mixed, and many of the cases involve the securities industry due to a type of agreement mentioned that the NASD, that is the National Association of Securities Dealers Incorporation, now they require brokers to execute in exchange for registration. Now, although the entire impact of Gilmer is not yet apparent, the case already has had a substantial impact on the employment context, with the majority of diseases follow the enforceability of an arbitration clause. Now, this is basically, I've tried to explain fundamentally and primarily the concept behind this. As I've already explained, that this culture has to develop in our country or in part of this globe. So if you want to further know what is happening in other parts of the world, we may have to organize a different lecture for this. Switch to second question, another question, because in our part of the country, it is not primarily, it is not so prevalent, and it is yet to take a shape.
Right,
It probably in the times to come it will.
Yes, sir.
Yes.
So proceeding with the questions, our next question is, based on your research, what advice would you give to organizations considering arbitration for resolving employment disputes?
Okay. Now, basic principles remain same, seat of the arbitration. Now, the seat of the arbitration determines the procedural law of the arbitration. Now, its importance cannot be overstated. Amongst other things, it determines the availability of interim remedies and rights of the award. Now, the seat of the arbitration may be different vis-a-vis the venue of the arbitration. That is where the arbitration will physically take place, and the governing law of the arbitration agreement. Now, most parties opt for a neutral jurisdiction as the seat, but they should not be the only consideration. The arbitral laws differ between countries and have important consequences on the efficiency of the arbitration and enforceability of an award. Recognizing this, various jurisdictions have developed various practices choosing a safe seat for arbitration. Now, what do we mean by safe seat? We have to understand that. So we can't go by just mentioning safe. What is safe seat? Let us discuss. Now, primarily the safe seat is set in a neutral or arbitration-friendly environment in which the courts support the arbitration. The legislature supports the arbitration. The laws support the arbitration. And this is an arbitration-friendly environment. For example, we may have heard Singapore
Right.
and other jurisdictions. This is basically, I'm just saying, like you will read in the newspapers and also in the media that a lot of cases of India go to Singapore. So basically it is the environment. That is what I meant with the safe seat. Now, next question issue with this, apart from seat, is the governing law of the arbitration agreement. Now, arbitration agreement is a contract in its own right. Now, consequently, the law governing the arbitration agreement, which in fact determines the validity and the scope of the arbitration agreement, can differ from governing law of the substantive contract. So, with this law students would definitely understand it, that there's a difference between the law which is related to the arbitration agreement as such and the law which governs the contract, the substantial law.
Right.
Now, the international contracts, the performance may be in one jurisdiction where now the governing law of the contract may be that of one jurisdiction, while the seat of the arbitration may be the another jurisdiction. The absence of an express provision for governing law for the arbitration agreement can lead to lengthy disputes, and most of the disputes are based on this only. Therefore, we give a lot of importance for this, the choosing of the governing law of the arbitration agreement. Now, arbitration agreement often fail to specify the governing law of the arbitration agreement. Therefore, it is my recommendation that the industry and the organization, they must consider this aspect, and the legal department must be sensitized, and they must be into deep looking at these aspects while finalizing the contract, and particularly while inserting the arbitration clause. The other point is the choice of rules. Now, this is one of the most important decisions when drafting an arbitration agreement, is whether to adopt the rules of an established arbitral institution, such as ICC or LCIA, or to govern the arbitration procedure. The main benefit of doing so is that institution, in return for a fee, plays a key role in administering the dispute, and their rules of a well settled, established, and predictable procedure. Now, what do we mean by this? Now, let us discuss in our own country. Now, within the Mumbai, we have Mumbai MCIA. Now, we have IMC. Then we have now coming up now in Delhi. Now we have Delhi International Arbitration Center. Again, a national level institution is coming up, IIAC. Now, similarly, in all other states, there are arbitral institutions. These institutions do have their own rules which govern the procedure, how the arbitration will be conducted. Now, similarly, the Indian Council of Arbitration, the ICA, all these institutions. Now, the question will come, what is the institution? Now, it is like, then we have to go into the point of the ad hoc arbitration or the institutional arbitration. So, I'm taking it for granted that at least this would be known. Now, like, I'm appointed by Bombay High Court as an arbitrator. Now, this would be an ad hoc arbitration. Suppose an arbitral institution appoints me, so that the rules of that arbitral institution would apply. and like Singapore Institute of Arbitration. Now, all these institutions, international or national or domestic, all these have their rules. And in their rules, they try and incorporate and they address the flexibility and also the finality and also a robust system to cater for the contingency which arise out of the dispute of while handling the arbitration. And these rules are updated periodically, and which take into account all the problems which are faced by the parties. If it is not an arbitral institutions led or governed arbitration, then ad hoc arbitration, we have the Arbitration Act that would apply. Yeah. So if the parties wish to refer their disputes to an ad hoc, unadministered arbitration, they should consider either setting out a bespoke process, adopting existing ad hoc procedural rules such as ancestral rules, or incorporating the rules of an institution, but making it clear that those provisions in which the institution plays an administrative role and receives fees for doing so will not apply. If this is not agreed prior to entry into the transaction between the parties, such options will need to be agreed between the parties later or as and when disputes arise. The parties can also consider using an institution as an appointing authority. So therefore, they don't have to run to the court under Section 11 for appointment of arbitrator. Because all these powers will be exercised, either the parties agree and appoint mutually, or then the arbitral institution will appoint. So they have, then another point is the language. Then this arbitration requirement, now it should identify the language of the arbitration, and it should form part of the clause, arbitration clause and the contract, where parties are from different countries and different languages. Now, it's an important choice as all submissions and evidence will be presented in that agreed language during the proceedings. Okay. In addition to that, selecting language that the parties most commonly use in their communication could also save significant translation and interpretation costs. Another factor is number and appointment of arbitrators. Now, how many arbitrators would you like your dispute to be resolved by? 1 or 3 or 5 or 7, or the panel of arbitrators of 3, or you want a sole arbitrator would suffice? Like the maritime disputes can also, they are generally resolved by the LMA, London Maritime Arbitrator Association. It is the 2 arbitrators decide. So, and generally, other than, we also have the policy when we have the formula of 1, 3, 5, or the odd numbers, so that there is no problem if both the arbitrators differ. Now, then after the number, the appointment of arbitrators, I have already explained whether it is by mutual agreement of the parties appoint, they agree on a common name, or they go for court intervention under Section 11 of Indian Contract, the Arbitration Act, or it is left to the arbitral institution. Now, another point is the specifying arbitrator. Now, we have to see that what is our requirement. Do you need the arbitrator having expertise of a particular nature or experience? What could be their qualification, experience? And all these are to be discussed and decided in advance. Now, the chosen criteria do not unintentionally include or exclude a class of potential arbitrators. That we have to see, and we have to be privy to this requirement. We do not lay down such a criteria which later we have a difficulty to address. Now, consolidation and joinder. Now, these are the points that will form part of a later lecture. We can consolidate the disputes and we can enable parties to join. So this is a different topic that I would cover in a different lecture, coupled with this like multi-tiered clauses. Now, multi-tiered clauses provide gateways for attempts at a negotiated resolution, allowing disputes to be gradually escalated from negotiation to mediation or conciliation, and finally to arbitration. Like I resolve disputes of the stock exchanges. There, the first tier is that they have a system of the conciliation process where a council or the committee appointed by the stock exchanges, they meet and try and resolve. And if that fails, and if party still feels aggrieved, then they go for arbitration. And even if in arbitration, if it is not resolved, then there is another system of appellate arbitral tier of system. And the panel of 3 arbitrators will decide. I sit as a sole arbitrator also, and I sit as a co-arbitrator also, and I sit as a presiding arbitrator of the panel also. So depending upon what you have with you in the contract itself and for what you have agreed. Now, other thing is that when we start drafting, my advice would be that please do not overcomplicate it. Keep it simple, because it will help you. More complicate is the provision, more difficulties it will give you at a later stage. Initially, you would like, I will cover this also, let me include this also, let me include this also. But you can't include and exclude all the contingencies. You won't know what contingency will arise in future. So keep it simple.
Right.
That will help you. And in addition to that, there are other points which generally the students are very well aware. I'll just touch upon those. They keep the drafts clear and fair of the arbitration agreements. And if you want and your management is agreeable, then provide options for opting out. And then select experienced and impartial arbitrators. And then ensure transparency and communication. And then stay informed about legal developments. This is very important, because this field is a very dynamic and evolving field. Every day, the provisions are being interpreted. Some judgments are coming from Kolkata High Court, some are coming from Chandigarh High Court. So daily, the high courts are evolving and wonderful interpretations are coming. So we have to be alive to all that. And then Supreme Court is also interpreting when it reaches Honorable Supreme Court is also, all this law is evolving almost on a daily basis. And then review and update of policies. And then we have to be in the industry, we have to balance the confidentiality with fairness. And then we have to educate employees about the arbitration process by various means which are available to us. And then it has to be an ongoing process. And then encourage employees to seek legal advice before entering into arbitration agreement. So the good industries, big institutions, they play a very important role, and they organize lectures, demonstrations, discussions, and various modus operandis are adopted. Then you have to consider industry-specific practices, which I have covered in the earlier questions.
Yes.
We have to continuously evaluate the effectiveness of this regularly, because it will enable us to take decision what we have gone through and what difficulties we have faced. I think this much is enough for your question. We can switch to next question.
Sure, sir. So this is a very elaborated answer. I hope it helps to the viewers and everybody who is studying arbitration. Proceeding with the questions, what advantages do you see in opting for arbitration and employment disputes?
Look, the basic principles remain same, and India logging the highest growth rate now across the globe. So more investment, more development, more disputes. It will bring in
Right.
more disputes. So
Right.
that is why it's a very dynamic and evolving field. So the points which are generally in the domain are very well known to the students. But since you have asked this question, so I will just briefly touch upon those. The key advantages include the efficiency and speed. These arbitration proceedings are often faster than traditional litigation in courts. The process is more streamlined with the fewer formalities, leading
Hmm.
to quicker resolution of disputes. Then, you can continue in the court for 40 years, 50 years. Your next generation will also
Right.
continue. You have heard and read a lot about this. And you also are aware of the load which our judiciary is coping up with. So,
Right.
it will be a dream only if you can have your dispute resolved in your lifetime. Now, another question is through the court litigation system. Now, another point is cost saving. It's a very cost-effective method compared to the lengthy court battles, and it is to minimize the overall expenses for both the parties. You can have in a 5-star a hotel, or you can have in a normal room arbitration or normal. Now, if you see next to any court or any high court, there are conferences rooms available on a very cheaper and reasonable rates. So you can opt on,
Hmm.
you have a 50,000 or a lakh per day, and you have 1,000 or couple of thousands rupees for 6 hours or 8 hours hearing. So it is cost saving. It's your choice, party's choice. Then the parties have a choice of decision maker. So this builds confidence. It gives a lot of confidence in parties that we have chosen our judge who's going to decide our dispute. So it instills confidence. And then the point which we have covered is confidentiality, that we want to maintain confidentiality. And because it's a private method of dispute resolution, and preserving confidentiality of the dispute is of paramount importance. Now, it is of importance that sensitive employment matters, protecting the reputation of both the employer and the employee. Now, it is not only the employer who is affected, the employees are also affected. What we have to
Exactly.
understand, generally we see that only employer is affected. No, the
Hmm.
employee also has a future. So if
Right.
he behaves in a certain manner, then he also sending the signals in the industry. He has to survive.
Right.
And then the word spreads very fast. And he has to move from one industry to another industry or one sector to another sector. And the word is very small.
Right.
And then they know that this gentleman has done this or that, there, or whatever. So it's the employer and employees both, while keeping the confidentiality. And some employers may have reasonable concerns about litigating internal workplace disputes in public trial. By contrast, arbitrations involve private filings and closed hearings. Internal disputes are unlikely to become external exhibitions by media-savvy plaintiffs' lawyers. So this is what the benefit comes with the arbitration. Then we have also discussed the flexibility in the process. The arbitration allows parties to tailor the process to their specific needs. They can choose the rules, location, and other procedural aspects, providing a more customized and flexible dispute resolution experience. Now, all this will be boosted, like we discussed, less adversarial atmosphere. It's an informal nature. It can foster a less adversarial environment compared to court litigation, and which in turn takes care of preserving the working relationship, especially when the parties involved may need to continue working together. So this is
Right.
wonderful. Now our topic, with this we have to see that when a case goes to the court, there is more of a likelihood that there will be a constant dispute and fighting on every single issue. This added hostility may never go away and may even make it difficult for you to do business with others later on. However, arbitration is a much more relaxed kind of environment. And while there is an existing conflict, it can be a lot easier to manage without hostility, because there's an arbitrator present and both the parties will have to cooperate with each other in order to reach a mutual agreement or arrive at a award passed by the arbitral tribunal. And this generally and invariably leads to a less hostility and can help keep the reputation of both the parties intact, that is, of the employer and the employee.
And the employee.
Then another point is the finality of decision. The arbitration awards are typically final and binding on both the parties, with limited grounds for appeal. The finality, this characteristic provides certainty to the parties involved, reducing the risk of prolonged legal battles and uncertainties associated with the potential appeals. Another point is about the international disputes. In the context of multinational companies, arbitration can be beneficial for resolving employment disputes, which cross-border disputes. Now, the arbitration provides a neutral forum and helps avoid the complexities of navigating different legal systems. This is the beauty of arbitration. And now we may have one party may be coming from the civil law, the other parties may be coming from common law. If the arbitral tribunal is sensitive of the law in both the countries, the background of the parties coming from different law systems, he will take into account. And it will be very easy for him to understand and comprehend that this is the process which is followed in civil law countries and this is the process which is followed in common law countries. So this is another. Now, expertise in employment matters. Arbitration in employment disputes often have expertise in employment law and related issues. And this can contribute to more informed decisions that align with the legal principles governing the employment relationship. Now, while these advantages make arbitration an attractive option, it is important to note that its appropriateness depends upon the specific circumstances and the preferences of the parties involved. So it is advisable that both the employers and the employees carefully consider the pros and cons of the arbitration and, if needed, seek legal advice before including and signing the arbitration clauses or incorporating those arbitration clauses into the employment contracts. So I think on this is enough for this question. Balance we can have on this issue later in case you feel a need so. Okay. Now
Sure, yes,
we can switch to other question.
Yes. So before that, I would like to apologize. This meeting too is to an end.
Okay.
So in case it does not end, sorry, sir.
Yes, please go ahead.
So summing up with the questions, this is my last question. What are your recommendations for employees who are seeking for arbitration?
Okay. Now, what we have is first of all, we have to review the employment agreement. That is the most important factor. Now, I would recommend that the employers and the employees, they must effectively navigate this in advance and they must carefully review the employment agreement or any other relevant document to understand whether the arbitration is mandatory or a voluntary process. That is what needs to be understood. And then take note of any specific procedures outlined in the agreement. Then the other point is that consult with your legal counsel. seek advice from an employment attorney or advocate or a counsel to understand your rights and obligations. And your legal advisor can provide valuable insights into the arbitration process, review and the arbitration agreement, and then advise you on the best course of action. Then another point which I would recommend is understand the arbitration rules. And both the parties have to familiarize themselves with the rules and the procedures of arbitration process. Now, most arbitrations follow established rules, and being aware of these could be of a great help both the parties to prepare effectively. Now, other recommendation which I would make is to prepare a strong case, gather and organize all relevant documents such as employment contracts, emails, performance evaluations, or any evidence supporting your claims, and prepare a clear and concise presentation of your case. Then another recommendation which I would make, that select an experienced arbitrator. And now arbitration process is now generally more prevalent, and it's generally the same, but like I deal with the commercial, the contractual. Also, I am qualified as a construction arbitrator. I am FIDIC qualified from Switzerland. I'm also like dealing into the, I'm handling an international maritime arbitration, which is seated in London, in which the English law is applying. It's under LMA. So you have to see the expertise and the experience of the arbitrator. If you have input into the selection of the arbitrator, consider choosing one with expertise in employment law or the specific industry. An experienced arbitrator can really contribute to a fair and informed decision. Because like I had studied labor law in my LLB, which I finished in 1980. And since then, because of this not being used much in country, now, of course, the labor unions, the industrial disputes, and the labor laws are also evolving. So now this is becoming a specialized field. So people who are now into this, they can really help you and guide you. And then once you have made up your mind, my recommendation would be then you must participate actively and proactively. Engage actively in the arbitration process, attend all hearings, provide relevant information, and be prepared to answer the questions. Act professionally and respectfully throughout the proceedings, which will help the parties, both the employer and the employees. And you must another recommendation which I would make, understand the decision-making process. Be aware as to how the arbitrator is making or will make decisions. Understand the factors which they will consider, the arbitral tribunal will consider, and the legal principles that apply to your case. Then another recommendation which I would make is to explore the settlement options. Consider exploring settlement options before or even during arbitration. Like mediation or settlement discussions may be very fruitful, allowing parties to reach a resolution without a full arbitration hearing. And then in this only I'll cover the latest, like the ARB, MedArb. And when you go for arbitration, in between you are referred to the mediation. If you settle good enough, if the mediation fails, you can come back to the arbitration.
Arbitration.
Yeah. Or if you succeed, then your settlement will be passed as a consent award by the arbitrator, which will be having a force. Now we have already had a mediation act coming into force. That's a different field which I don't, because because I'm an accredited mediator also, so I will now not dwell much on this because it is we are considering now the arbitration to disputes. So, but we have to be aware of this because that option is also available. Then my recommendation would be that be mindful of deadlines. We must adhere to the deadlines set by the arbitration process, and failing to meet the deadlines could have serious consequences. And stay organized and be responsive throughout the proceedings. Then maintain professionalism. Approach the arbitration process with professionalism and respect. This includes interactions with the arbitrator, opposing party, and any legal representatives who are involved. Then stay informed. Both the parties are required to stay informed about any developments in the employment laws or procedure that may impact your case. And then knowledge of relevant legal principles can be empowering during the whole arbitration process. Now, then the understanding discrimination and harassment laws. Let me cover and let me touch upon briefly on this, that if one believes that one has been subjected to discrimination or harassment in workplace, it is crucial to understand the relevant laws and regulations. Then one has to familiarize himself or herself with the central and the state laws that protect employees from such misconduct. Then document incidents, gather evidence in consultation with an experienced employment advocate, which will determine the best course of action. And we have to remember that each employment dispute is unique. And advice of a legal professional who understands the specific details of your situation is very crucial. So these recommendations are generally the guidelines, and consulting an employment advocate will provide tailored guidance based on your circumstances. You may need a different, your needs are different, and it really needs a tailor-made solution. Exactly. So with that, I think I've covered much, and it has done justice to your question. And since it was the last question, so I have to thank you, Nandini, and your entire team, which has taken this initiative. And I also must thank Mrs. Shivangi Sinha, who is head of the cell, and team of Madhyastha ADR cell, and the Honorable Vice Chancellor and all the faculties of Bharati Vidyapeeth, deemed to be University, New Law College, Aran Vani campus, Pune, Maharashtra, India. Thank you so much. Wonderful discussion. I'm grateful to all of you to have afforded this opportunity to me to sensitize on this important aspect, which is evolving and which has a great future. I don't say that it has a great future for disputes, but I would say that the great future for resolution of disputes.
Yeah, right.
So with that,
we really appreciate, sir.
Thank you so much.
Thank you so much for your time, sir. It means a lot. Like having a knowledgeable guest like you, it's an honor for our field, sir. Thank you.
Thank you so much. Convey my regards to all your colleagues, seniors, and peers. Sure, it was a wonderful experience being with you, and looking forward for another opportunity. Thank you so much.
Same here, sir. Thank you, sir.
Bye-bye.
See you someday soon.
Yeah.
Thank you, sir.